He made statements to his friends, this idea of, I think my wife is trying to poison me. Now, is that hearsay? Absolutely. He is making a statement. He is not present in court to testify to it, obviously. He's making a statement, it's an out-of-court statement, and it is being offered for the truth of the matter asserted. That's what makes it hearsay. If it wasn't being offered for its truth, then what's the relevance of it? Utah mother and notorious grief author Kouri Richins, accused of poisoning her husband with a lethal dose of fentanyl, has been ordered to stand trial for his murder. Plus, Vegas politician Robert Tejas has been found guilty for the stabbing death of an investigative journalist, despite his personal pleas to the jury during 3 days of grueling testimony. And the family of Boston police officer John O'Keefe have decided to take matters into their own hands by filing a lawsuit against Karen Reed for wrongful death. All this and more this week on Courtroom Confidential. It has been one of those weeks, folks. There is so much going on, a lot to cover, and so much going on from different sides of the legal field. I mean, we've got cases that are just beginning at preliminary hearing stage. We've got cases that now have verdicts. We've got cases that have gone from criminal to civil and are continuing to be criminal. But we're going to jump into all of that and cover as much of the interesting aspects of each of those as we can. So let's go ahead and begin with a Utah mother of 3 who published a children's book about grief after her husband's death and was later accused of fatally poisoning him, will stand trial, a judge ruled this week. Utah State Judge Richard Mrazek ruled on the second day of Kouri Richins' preliminary hearing that the prosecutors had presented enough evidence against her to proceed with a jury trial. Prosecutors say in March of 2022, Richins slipped 5 times the lethal dose of fentanyl into a Moscow Mule cocktail that her husband Eric Richins drank before dying at their home in a small mountain town near Park City. The second day of her preliminary hearing centered around an additional attempted murder charge filed earlier this year that accused her of slipping fentanyl into her husband's sandwich on Valentine's Day of 2022, causing a severe but not fatal reaction. Prosecutor Brad Bloodworth argued the state's theory that Kouri Richins learned lessons during the first unsuccessful attempt on her husband's life that helped her carry out the killing 17 days later. In written testimony, 2 friends of Eric Richins recounted phone conversations from the day prosecutors say he was first poisoned by his wife of 9 years. After injecting himself with his son's EpiPen and chugging a bottle of Benadryl, he awoke from a deep sleep and told a friend, "I think my wife tried to poison me," charging documents allege. Defense attorneys Kathy Nestor and Wendy Lewis argued that because police never found fentanyl in the Richins' home, detectives could not be certain the drugs that Kouri allegedly bought from their housekeeper matched those found in Eric Richins' system. These are great trial arguments, Mrazek responded, but ultimately decided that the arguments were not strong enough to make the case that there was not probable cause to proceed to trial. Kouri Richins sat expressionless as the judge delivered the news that a jury would soon decide her fate. Her trial is set to begin April 28th of 2025. All right, what's happening here? First, I think it's really important to understand what a preliminary hearing really is and what it is not. A preliminary hearing, or a prelim, is what we call a probable cause hearing. Every single state handles this a little bit differently. A lot of states handle it by way of indictment. Many states handle it by way of a preliminary hearing. All of them essentially function in the same way. And what that is the idea that you cannot be charged, according to our Constitution, with a felony or misdemeanor, any crime, quite frankly, but we're dealing with felonies here, without a judge, an independent arbitrator, an independent review of that evidence taking place to determine that there is enough probable cause to, quote unquote, hold that person or bind that person over for trial. Meaning, we are putting past the days when we wrote the Constitution of people just getting arrested and locked up and held for forever with zero evidence. Now we're saying you have to show your hand. The prosecution has to present some evidence to a judge to show that there's, quote unquote, probable cause to hold this person to answer at trial. Probable cause is a much lower standard than beyond a reasonable doubt, obviously. And because of that, a prelim is a much shorter hearing, and you're not going to have it in front of a jury. It's only in front of a judge, and it's not going to present all of the evidence. And there's a lot of different shortcuts in some of the rules. For instance, hearsay rules. In California, where I practice, there is a rule that allows for a police officer to testify to almost any hearsay. Many times in a prelim in California, you will see one officer get up and testify to what nearly every other officer did. This officer found the weapon, that officer collected the weapon, that officer spoke to the defendant, all of these different things, and you'll have one police officer testify to all of it. And it's a way of fast tracking this process because, like I said, the same evidentiary rules don't apply at a prelim because we're not dealing with locking someone up forever. We're only dealing with the concept of binding them over for trial. And we want to be able to kind of streamline these things so that the whole system doesn't get clogged up at the prelim level. In Utah, they do a little bit of the same thing in regards to hearsay, in that their rules are, the best way to put it, a little bit more flexible. And some things are allowed to come in that might not otherwise come in at a trial. One of those things happened here with Eric Richins' friends. He made statements to his friends, this idea of, I think my wife is trying to poison me. Now, is that hearsay? Absolutely. He is making a statement. He is not present in court to testify to it, obviously. He's making a statement, is an out-of-court statement, and it is being offered for the truth of the matter asserted. That's what makes it hearsay. If it wasn't being offered for its truth, then what's the relevance of it? So its only relevance is the idea that he believed that, and he actually believed that's what she was trying to do, and that's the whole reason the prosecution wants it in front of a jury. Now, they got it in at prelim. The question becomes, will they get it in at trial? Well, as you know, hearsay doesn't necessarily mean it's not coming in. There's exceptions to hearsay. We have the dying declaration statement. If he felt, and they can argue that at the time he was making that statement, he actually believed he was dying, perhaps then there's some trustworthiness to it. This is all what hearsay is about, is trustworthiness of the statement. I don't think that argument will win, dying declaration. It could be his state of mind. What was he thinking of the time? He was talking to someone and he thought his wife was going to kill him, and therefore he adjusted his insurance policies, or therefore he spoke to his business partners about plans in case he died. Those might be a reason to allow it in, because you could understand why he took next steps based upon his current state of mind. Also, a current just statement of someone's existing physical state. If somebody says, oh my God, my stomach hurts, that's usually the kind of hearsay exception that we might allow in, because they're giving this almost kind of contemporaneous expression of how they're feeling. The problem in this case, and why I think a judge might really scrutinize it, is, like I said, hearsay comes back to trustworthiness. But in every decision a judge makes, he's weighing two things. He's weighing the probative value of that evidence against its prejudicial value. And many times those things can be high on either side, as we're dealing with here. The probative value of Eric Richins saying, I think my wife is trying to kill me, is huge as far as the prosecution is concerned in this case. But if that statement lacks certain amount of trustworthiness because of perhaps it running askew of the hearsay rules, does its prejudicial value, the way that it would hurt the defense case, outweigh its probative value? I know we're really getting into the weeds here. I guess the long and short of it, of what the point I'm trying to make, is this. These statements are incredibly powerful. The prosecution wants them in. They got them in for the purposes of prelim, but this could be a real game changer on whether or not they get those statements in at trial. And that is yet to be determined, because even the judge himself said he's going to wait to decide that issue. All right. What do you guys think, though? That's what I really want to hear. Do you think this evidence is as crucial to the prosecution case as I think that it is? Please let me know in the comments. Moving on, a former Las Vegas County official was found guilty on Wednesday of murdering a longtime investigative reporter who wrote articles critical of him. Robert Tejas hung his head, shaking it slightly from side to side as the verdict was read. A panel of 7 women and 5 men found Tejas guilty of first-degree murder in the September 2022 slaying. The jury spent nearly 12 hours over the course of 3 days deliberating until reaching a guilty verdict, and then deliberated for just over an hour before determining that Tejas should spend life in prison with the possibility of parole in 20 years. Jurors weighed 8 days of testimony from dozens of witnesses, including detectives, forensic experts, and those who knew Tejas, along with 3 days of testimony from Tejas himself. Tejas gave a narrative testimony to the jury without being interrupted by his attorney before facing cross-examination by prosecutors. If you would like a more in-depth discussion of this testimony, I did 2 videos where we went through all of his testimony, reacting to it, and giving commentary on how effective or not it was. If you'd like to check those out, available on the channel now. Prosecutor Christopher Hamner told jurors during closing arguments Monday that Tejas blamed Gehrman for destroying his career, ruining his reputation, and threatening his marriage. He said Gehrman fought to the death with his attacker and reminded them that DNA that matched Tejas was found beneath Gehrman's fingernails. Tejas, age 47, will return for sentencing scheduled for October 16th. What's happening here? I don't have a whole lot to say about this other than you just never know what jurors are thinking. I have been doing this long enough to know that I do not know what juries are thinking. One of the favorite pastimes of trial attorneys, aside from doing trial, is trying to read the tea leaves of what jurors could possibly be thinking. And to me, this case was a slam dunk. To me, the evidence in this case was overwhelming. I mean, you had, the videotape evidence that captures the killer wearing a hat. Fragments of that cut up hat are found inside Tejas' home. The getaway vehicle matches a vehicle registered to Tejas' wife. The high motivation factor, on and on and on and on. And if that wasn't enough, if all of that wasn't enough, the defendant's DNA is found under the fingernails of the victim. 2 people who had no reason on earth to ever meet each other than Tejas taking this man's life during a stabbing. To me, that's a rock solid case. And it took the jurors 3 days to arrive at that. During that time, they had some questions. One of their questions was, how do you zoom in on a video? I can only imagine what it was like for the prosecutors as this was going on. They must have been pulling the hairs out of their head to think, what are these people thinking? What question could they possibly have? Where did we fall short? Why in the world do they want to re-examine this evidence and zoom in on the video? And there was a lot of discussion, and I follow your comments online and the comments that you leave on the channel about an argument that the defense made in closing arguments about the silhouette profile of the driver of the getaway vehicle and whether or not that looked like the defendant. And there was some discussion made by the defense, or argument made by the defense, that person in the videotape there, that profile has hair. And you take a look at the defendant, and he obviously has no hair. One of his distinguishing features is his bald head. Was that the question? Was that a good question? Was that something that maybe made jurors think twice about this? Could be, but the answer is, who knows? Who knows what they were really hung up about? They obviously were diligent, and I'm not criticizing them. I'm just remarking on the fact that sometimes you have a case that you feel is rock solid and it takes forever to come to a verdict. Sometimes you have a case that you feel has big problems with it and verdicts are arrived at quickly. If you've been doing this long enough, either as a practicing trial attorney or as a courtroom spectator, you know that you just never know. But what do you guys think? Were you shocked by how long this all took? Do you think that this was just a long, complicated trial and they were really trying to do their best job? Please let us know in the comments. The family of a Boston police officer filed a wrongful death lawsuit Monday against Karen Reed, the Massachusetts woman whose murder trial and the officer's death ended with a hung jury in July. The civil suit, filed in Plymouth County Superior Court by relatives of John O'Keefe, also accused two bars of wrongful death, alleging they served Reed alcohol when she was already intoxicated on the night of January 28, 2022. The lawsuit accuses one of the bars, C.F. McCarthy's, of serving Reed 7 drinks over roughly 1.5 hours on the night of January 28th. The second bar, Waterfall Bar and Grill, allegedly served Reed a shot and a mixed drink shortly afterward. The suit goes on to allege that after she left the second bar around midnight on January 29th, Reed drove O'Keefe to the Canton house where another Boston officer was having a gathering. According to the lawsuit, O'Keefe and Reed had been arguing when O'Keefe got out of the vehicle and Reed fatally struck him. The lawsuit goes on to conclude that Reed, quote, knowingly and deliberately changed her story and fabricated a conspiracy knowing the same to be false. She publicly communicated this false narrative, thereby frustrating justice for O'Keefe. Such false narrative caused the plaintiffs aggravated emotional distress. What's going on here? Well, shots fired. Absolutely. This is the O'Keefe folks going on the offensive. I think they are frustrated with how long this has all taken. I think they are frustrated that the first trial ended deadlocked. I think that they have seen a lot of missteps by the prosecution. They have seen the police department come under fire in ways that we're going to talk about even more later on today. And they have thought to themselves, we're not going to wait anymore. This is not entirely uncommon for there to be both a civil lawsuit and a criminal case. Famously, we saw this in the O.J. Simpson case. During that entire trial, the families of the victims that O.J. Simpson was accused of killing had attorneys, and they had lawsuits, and they were waiting in the wings for that trial to end. And that's usually how it goes for a couple of reasons. One, a civil trial can rest upon the work done at a criminal trial. If you get a verdict of guilty at a criminal trial, you could submit that verdict as evidence in your civil trial to show that essentially already 12 people have decided at a much higher burden than a civil burden that this person is guilty of the crime, which is related to the civil cause of action we are bringing in this case. But another reason they wait, and kind of important to our discussion here, is Fifth Amendment protections. Part of why a civil suit is interesting in this case is the discovery process. In a criminal case, the police can sit down and ask questions of the defendant, and the defendant can say, I don't want to talk to you. I got nothing to say. By the way, so can witnesses. Witnesses do not have to cooperate with police. Now, I don't want to get into the weeds on whether or not they can actually lie to police, but in some jurisdictions, you can even lie to the police and that not be a crime. Federally, things are a little bit different. But my point is this: the gathering of evidence, the defense enjoys many more protections criminally than they would enjoy in a civil forum being sued. When you're being sued, you have to comply with things like interrogatories, written questions that are sent to you that you must answer under oath, requests for admission, things that they ask you to admit to. Yes or no? Do you admit this under oath? The penalty for violating those things or lying on those things can be severe. Again, we're not talking about criminally, we're talking about civilly. So when I say severe, I'm meaning probably hurting your wallet more than it's hurting your freedom. But still, requests for documents. They can start asking us, hand over your phone records, hand over your bank records, hand over a bunch of things. And they're compelled to do that. But where the real teeth in a civil case lies is in the taking of depositions. Believe me, when I was a prosecutor, I would have loved to depose my defendant. Sit him down and say, I got some questions for you before we even start this trial. can't be done because of Fifth Amendment protections. In a civil context, you don't have a Fifth Amendment protection. Now, you can still refuse. You have the freedom to say, I don't want to participate, but there will be ramifications, and those ramifications might be that you lose your lawsuit by default and all this money is awarded to the plaintiffs. So it's in your interest to cooperate. Now, getting back to when you have both of these things happening at the same time, it's going to be hard to depose a defendant civilly who's also a defendant criminally, because they can say, I still have a Fifth Amendment concern and I don't want to participate and answer questions in this deposition. And judges will oftentimes allow the criminal process to play out and not force the defendant to take the fifth during these depositions. So what I like about this is, one, it's aggressive on the part of the O'Keefe family. And two, it's really starting to open up a lot of interesting avenues for finding out things that we might not have learned before through the routine criminal investigation process. Certain people can be deposed, not just talking about Karen Reed, Karen Reed's father, Karen Reed's mother, other people she may have been close to and confided in. They can be deposed, whereas their cooperation was not compelled from a criminal perspective during the criminal case and the investigation of that. And that's why this last kind of sentence added in that lawsuit of changing her story, fabricating a conspiracy that caused emotional distress, also becomes interesting. In a criminal case, you're allowed to have a defense. That defense can be something that, and again, don't start shooting arrows at me here, but that defense can be something that you make up. The burden is on the prosecution, and the only burden on the defense is to try to poke holes in all of that, zealously advocate for their client, and not flat out lie. But they're allowed to present theories, and that's what they did in Karen Reed's case. Now this lawsuit is saying you knowingly promoted, and not so much in the courtroom, but in her conferences outside, her news conferences and her statements to the media. Was that something that was a false narrative that she knew to be false? And how do they get to the bottom of that other than by deposing her or deposing people close to her? So again, I'm doing a lot of kind of looking to the horizon, but to me, this was a very interesting move because of all of the interesting things that could come out of it. And it's also putting a lot of pressure on the Karen Reed camp. But what do you guys think? Was it a good strategic move? Is it a waste of time? Is this all a big nothing and to be expected? Please let me know in the comments. Before we dive into the other cases making headlines this week, I only want to take a moment to ask you one very small favor, and that is, if you haven't already, please subscribe to this channel. It helps us out immensely in growing this channel and being able to offer you more and more content and perks and all of the things that we have in store. And don't forget to check out Courtroom Confidential as a podcast as well. Please join our community on all of the major podcast platforms. Also making headlines, a man convicted of killing 2 Florida women in 2019 was sentenced to death Tuesday. With a face covered in tattoos, Wade Wilson, dubbed Deadpool Killer, as he shares a namesake with the Marvel Comics character, showed no emotion as the judge handed down the sentence. The 30-year-old was found guilty of strangling Christine Melton to death as she slept the morning after he met her at a bar, and then beating, strangling, and running over Diane Ruiz with his car after seeing her on a street later that same day. The evidence shows the murders were heinous, atrocious, and cruel, and that the second murder was cold, calculated, and premeditated, said Circuit Judge Nicholas Thompson during sentencing, agreeing with the jury's recommendation of 2 death sentences, 1 for each murder. A teenager accused of killing her mother, lying in wait to shoot her stepfather, and inviting a friend to view her mother's dead body will head to trial after rejecting a plea offer from prosecutors. Carly Gregg, only 15 years old, was indicted on charges of first-degree murder, attempted murder, and tampering with physical evidence for the shooting that killed her mother, Ashley Smiley, and injured her stepfather. At a hearing on Tuesday, Gregg told the court that she had rejected a deal from prosecutors that would have sent her to prison for 40 years for murder and dropped the additional charges. If convicted, Gregg faces a sentence of life for the murder. She is due back in court on September 10th for a motions hearing, including a motion to transfer her case to youth court. A former Stoughton, Massachusetts police detective has been federally indicted in the death of Sandra Birchmore, accused of killing her and then staging her apartment to make it appear she had committed suicide. Matthew Farwell of Northeastern is accused of having a sexual relationship with Birchmore from the time she was 15 years old until she was 23, killing her sometime after she told him she was pregnant with his child. Federal prosecutors say he did so to prevent her from revealing their relationship and his alleged crimes tied to it. The former officer was arrested on Wednesday morning and charged with one count of killing a witness or victim. He pleaded not guilty, according to prosecutors, and will remain in custody until a detention hearing next month. Before we get into what's on the docket for next week, I want to just take a moment to tell you guys how much we appreciate the love and support from our growing community. It has been absolutely amazing. But we wanted to give a special shout out to A.G. Kearley for their wonderful review on Apple Podcasts, and to our newest members, Simi Sharp 9911 and Linda McCog 3645 for their kind words on YouTube. Keep them coming, folks. We highly appreciate your feedback. On the docket for next week, New Jersey lawyer Matthew Nilo will return to court on September 5th for charges he raped 3 women and tried to rape a 4th as prosecutors continue to gather the evidence they need before trial. Former San Diego TikToker Ali Abulaban, known as Gin Kid, convicted of killing his estranged wife and her friend at an East Village high-rise apartment building in October of 2021, will be sentenced on September 6th. Abulaban faces life without parole. Doomsday mom Lori Vallow will be back in an Arizona court for a status conference on September 6th. Vallow is accused of conspiring in the fatal shooting of her 4th husband, Charles Vallow, and plotting the attempted murder of her niece's ex-husband, Brandon Boudreaux. Finally, folks, in an effort to continue to bring you guys more quality content, we have decided that it's just too long to wait to every Friday to get updates on what's been happening during the week. That's why we are adding new programming to our lineup. Wednesday Night Lives. Join us every Wednesday as we catch up on breaking news or just hot takes on what's been happening in continuing cases. Please stay tuned to our channel and community feed for more updates. That is it for us this week, folks. I am your host, Josh Ritter. You can find me on social media at Joshua Ritter ESQ or at joshuaritter.com. Thank you again for joining me. Have a great weekend, and I will see you again next week for another episode of Courtroom Confidential.